but it was the subject of a petition. In 2013, there was a petition dealing with nothing but rejected votes. Rejected votes, Madam CJ, can be the third candidate. It's very easy for rejected votes to be the third candidate. And in 2013 at Bomas, where I had the pleasure and privilege of being the chief agent for the candidate, it became quite obvious that rejected candidates will be the third candidate in that contest. And if they were to be factored, then the whole purpose of rejected votes is to bring down the victory of the candidate who would otherwise have won. So it is a point we litigated at length. Some of my learned friends, my seniors, we litigated at length, and this court held and found that what is to be considered are the valid votes cast. So in my submission, that is a point that has been dealt with. It was again repeated by the court in Ghana. Last year, they rejected the notion of considering rejected votes in the final tally. As a matter of fact, now that I remember, I'm getting a little older, I was clearer then in 2013, it is a misconception to call them rejected votes. It is actually rejected ballot, because a vote is that which is valid, which expresses a choice. So those so-called rejected votes are actually rejected ballot papers. The same holds true for spoiled ballots, and the same holds true for stray ballots. As fate would have it, you will not even know about the stray ballots at the point that the tallying is going on. I associate myself with the submissions made by my learned friends, IEBC. They are the ones who conducted the election. It is not within our place to supplement their submissions. We wish to associate ourselves with the submissions, particularly as regards how the election was conducted. I come to what is the elephant in the room, to quote Tata, who I have never quoted before. What is the way forward? On the one hand, you are being requested by many of my learned friends, actually all of them in unison. Is the first time I have seen so many lawyers making the same request: nullification of the election. Almost reminds me of the trial of Christ. Crucify him, nullify the election. After nullification of the election, no solution is provided. But all they request is nullify the election. As you consider the rival position, I will request you to consider the following. In the event you nullify the election, you will effectively be rejecting the substantive truth that the majority of voters in this country express their free choice. While considering that plea of nullify the election, we shall be acceding to a very dangerous trend in this country, that presidential elections are to be held, and if I'm aggrieved, not because of any error, but I want to hold the country at ransom, I will walk to the Supreme Court and the election will be nullified. While considering that request, please also consider the far-reaching consequences that we all participated, we all experienced in 2017. That is on the one hand. On the other hand, the first and second respondent come to you with a request. The request is, voters did exercise their right. Hold them to that covenant. The covenant is they made a choice. Do allow the country to now move forward. We cannot and cannot afford election mode in perpetuity. I think I have said enough to demonstrate where my mind is. It is time for finality and stability. Finality and stability. In doing so, Madam Chief Justice, you'll be sending yet another signal to the political class. And here I am not finger-pointing anybody. As I said in 2013, what I say for this client is what I'll say for the next client who is in that class. The country does not belong to them. This country belongs to all of us. And since the country belongs to all of us, no person should consider that there is an entitlement. Considering that there is an entitlement is to engage in an illusion. That illusion ought to be replaced by reality. Reality is that it is voters who make their choice. And once voters have made their choice, let us inculcate a culture that my brothers and sisters on this side are now used to. We walk to our court, we may think the law is on our side, we may think we are entitled to victory, but we accept the verdict of the court because much as we may think we are eloquent litigators, the final word is always with the court. With those comments, may I very humbly and respectfully request this court to let this cycle come to an end so that we can get back to our business, the business of developing our country. With those remarks, I would wish to close and to donate the 30 minutes to the court because we are patriotic enough to know that it's not really in the interest of this country to engage this never-ending circle of litigation. Thank you very much. Unless you have any questions for us, that's the end of our case.
Thank you very much. We appreciate the donation and the appreciation that this time that we have is very, very tight, because for us, the work actually begins when we finish all this. The bench will have questions to those submissions that have been made today, but I think there are a few who might also want to add some questions to the petitioners, especially the commissioners who are supporting the petition. I think what we want to do now is take a short health break, resume at 5:20, and this is going to be the order of business. We will ask questions to the petitioners and the commissioners who are supporting the petition, they will still respond tomorrow when they are doing their responses. But for the respondents, the first and the other respondents, we will request them to answer today the questions. We will also share the report on the scrutiny and the orders that were issued by this court on the discovery issues, the application by the petitioners. I think it was the first petitioner, Kerif Karifa, and the youth advocacy. They had applications for scrutiny. That report is being finalized. It will be shared. And tomorrow we will give you an opportunity to respond to the report. So we will adjourn for just 20 minutes.